Picture a Tuesday night, nothing remarkable about it. A driver pulls out of a parking lot, merges onto a two-lane road, and drives exactly the way they always drive. Then the lights come on. No swerving, no speeding, no real reason for what's about to happen. And what unfolds over the next 11 minutes on the side of that road is something every driver in this country needs to see. Because this driver did something almost nobody ever does at a traffic stop. Something that felt uncomfortable. Something that went against every social instinct a reasonable person carries. They said almost nothing. Not because they were hiding something. Because they knew something the officer standing at that window was counting on them not knowing. And by the time those 11 minutes were over, the officer had nothing. No admission, no contradiction, no legal foothold of any kind. This video breaks down exactly how that happened, why it worked, and how you can do the same thing the next time someone decides your car looks interesting enough to fish through. The stop. That had no real reason to go further. The officer's stated reason for the stop was a lane change without a signal, a technical violation, the kind of thing that generates a warning on a slow night and nothing more. Under Rodriguez versus United States, decided by the Supreme Court in 2015, the mission of that stop was legally defined the moment the lights came on. Check the license, check the registration, address the lane change, release the driver. That is the complete legal scope of what just happened. But the officer had other ideas. Before the license was even back in his hand, the question started. Where are you coming from tonight? Where are you heading? Do you live around here? Have you had anything to drink this evening? Is there anything in the car I should know about? One after another. Casual in tone, conversational in delivery. Each one designed to open a door that the officer could then walk through legally. Each one requires only one honest, nervous, well-meaning answer to give the stop an entirely new direction. The driver recognized every single one of them for exactly what they were. The silence that changed everything. Here is what the driver said in response to the first question, and the second, and every question that followed. Officer, I would prefer not to answer questions. Am I being detained or am I free to go? That is it, said calmly. Said respectfully, said without hostility, without aggression, without any of the nervous energy that officers are trained to read and document as behavioral indicators of guilt. The officer pushed back. He said it was just a simple question. He said cooperative drivers had nothing to worry about. He said this would all go faster if the driver just answered a few things. The driver did not move. Officer, I have provided my license and registration. I am exercising my constitutional right not to answer further questions. Am I being detained or am I free to go? Same words, same tone, same complete absence of the emotional reaction the officer was waiting for. Here is what was happening legally in that moment. The Fifth Amendment to the United States Constitution protects every citizen from being compelled to be a witness against themselves. That protection applies at a traffic stop exactly the same way it applies in a courtroom. The driver was not required to answer a single one of those questions. Not one. And the act of declining to answer cannot legally be used as evidence of guilt or as grounds for detention. The Supreme Court was explicit about this. Exercising a constitutional right is not probable cause for anything. The officer had no new information. He had no contradiction to exploit. He had no admission to build on. He had nothing but a driver sitting quietly behind a wheel with their hands visible and their rights fully intact. What the officer needed and never got. This is the moment I want you to understand completely because it is the heart of everything this video is teaching. The officer needed one thing to legally extend that stop beyond the lane change. One thing. A single articulable fact pointing toward criminal activity separate from the original violation. Under Rodriguez, that is the legal standard. Specific, articulable, independent of the original stop. He tried to get it through conversation. The driver gave him nothing. He tried to get it through pressure. The driver gave him nothing. No nervousness beyond what any reasonable person would display. No contradictions because there were no statements to contradict. No suspicious movements because the driver stayed still, calm, and composed throughout. He tried to get it through pressure. The implication that silence was suspicious. The suggestion that a cooperative person would just answer the questions. The social discomfort of a long pause after a direct question. The driver let every single pause sit there untouched. Because here's what most people never understand about silence in a legal encounter. Silence is not suspicious. Silence is not evidence. Silence is a constitutional right being exercised correctly by someone who understands that the burden of proof in this country sits entirely on the government and not on the citizen sitting in that car. The officer had 11 minutes of nothing, and nothing is exactly what showed up in the report. Why most drivers would have failed. This same stop, let us be completely honest about something. Most drivers would not have made it past the first question. Not because they are weak, not because they are guilty, because the social pressure of that moment is almost physically overwhelming for someone who has never been prepared for it. Think about what it feels like to sit in a car with an officer standing at your window, a flashlight in your face, a question hanging in the air, and a voice in your head screaming that silence makes you look guilty. Every instinct you have been raised with is telling you to talk, to explain, to be friendly and open and transparent because that is what good people do. That instinct is the fishing rod, and the moment you start talking, you are the fish. The driver in this story had done one thing differently from most drivers they had ever met. They had learned in advance before the lights ever flashed in their mirror exactly what they were and were not required to say. They knew the Fifth Amendment applied at a traffic stop. They knew silence could not be used against them. They knew the question, am I being detained or am I free to go force a legal declaration? The officer had to answer honestly. They were not lucky. They were prepared. And preparation is the only thing that separates a clean record from a costly mistake on a Tuesday night with no remarkable reason for anything unusual to happen. The exact framework that shut the fishing trip down. Here's the complete framework this driver used, step by step, word for word, ready to use the next time someone decides your car looks interesting. Step 1. Pull over promptly, smoothly, and completely. Both hands are visible on the steering wheel. Engine off. Wait for the officer to approach without reaching for anything. Step 2. Provide your license, registration, and proof of insurance when asked. Hand them over without commentary. These are your only legal obligations during a standard traffic stop in every state in this country. Step 3. When conversational questions begin, say this: Officer, I would prefer not to answer questions. Nothing more, no explanation, no apology, no elaboration. Step 4. When the mission of the stop feels complete, say this: Am I being detained or am I free to go? Wait for the answer. If the answer is you are free to go, leave immediately and politely. Step 5. If the officer says you are being detained, respond with this: I would like to speak with an attorney before answering any further questions. Then stay calm, stay quiet, and let your attorney handle everything that follows. Step 6. Never consent to a search under any circumstances. If asked, say clearly, I do not consent to any searches. Say it once. Do not repeat it. Do not explain it. Do not negotiate it. That is the complete framework. 6 steps, built entirely on documented constitutional protections, used by the driver in this story to walk away from an 11-minute fishing trip without a single charge, a single admission, or a single word that could ever be used against them in any courtroom anywhere. Here is what Tuesday night actually taught. The officer on that road was not a villain. He was doing his job within a system that rewards observation, questioning, and the willingness to push until something gives. The problem was never the officer. The problem was the assumption that the driver would behave like every other driver, that the social pressure of the moment would be enough to open a door that the law never required them to open. It was not enough, because this driver had done the one thing that changes everything at a traffic stop. They knew their rights before they needed them. They knew the words before the moment arrived. They knew the silence was legal before the pause became uncomfortable. And that knowledge, sitting quietly inside them while the officer asked question after question on the side of a Tuesday road, was the only weapon they ever needed. You now have that same knowledge. The question is whether you will remember it when the lights flash and the pressure arrives, and every instinct you have is telling you to just answer the question. Remember this video. Remember the framework. Remember that silence is not guilt. It is a right. And rights that go unspoken protect nobody. Share this with every driver you know before you close this app. because somebody in your life is heading toward a fishing trip they do not see coming. And this video might be the only net they ever have. Subscribe because every video here is built around one purpose: making sure you are never the driver who did not know. Know your rights like your freedom depends on it, because on the right Tuesday night, it absolutely does.